now what every client wants to know, right? How much does all of this cost me? Is it worth it? What am I going to get out of it? Can I stay like my district court option pending the post-grant proceedings?
Yeah, so if you're looking at these numbers and thinking, man, this stuff is expensive, you are completely right. And I will just say, well, the first row is set by statute. So those are fixed costs. Second one as well. Legal fees really vary by the facts of the case. So I think this is a solid estimate here, but don't be running off and thinking this is like a quote that you should, be giving to clients and things. In general, and maybe one of the perks of using ex parte reexam is the legal fees are generally substantially lower. I want to caution you a bit that maybe $20,000 is a little lower, depending on the complexity of the issues involved than I would maybe think myself. Can it be done for this? Of course. The best reexams, in my view, and I think Michelle agreed with me, she's done a bunch of these as well, are written almost like an IPR, but maybe throw in a little bit more in terms of other stuff that are required in an ex parte reexam. Like you don't have a page limit, so you can slap some claim charts on the end to make sure you're really covering every limitation. You might be able to throw in additional grounds because you don't really have a hard and fast page limit or word limit like you do in an IPR. Those types of things can drive up fees. One place where you can save money, though, if you're looking to do so, is ex parte reexam. Absolutely nothing to do after you file the initial, with the caveat of the reply to the patent owner statement. So when you look at the PGR and IPR columns, you can see there's numbers through hearing, numbers through appeal. As a requester in an ex parte reexam, you don't get to participate in any of that. So your legal fees in theory are cut off as of the filing date of your request. Couple caveats to that, of course, but generally that keeps the fees down. You have no discovery, your expert's not going to be deposed. A lot of that stuff that gets expensive just doesn't exist. But going back to the big strategic decisions, are those weak points in your argument? Do you have what you need from one filing, where in an IPR PGR, you're getting multiple papers and opportunities to argue before the board? Here, cheaper maybe, but you're losing a lot of the advocacy that might be beneficial to really win out the day. So everything's always a trade-off. In terms of a district court stay, this is also highly fact-dependent across the board. So there's a set of factors. It does vary a bit court by court, but the big one that every district court really looks in at is how likely is it that this proceeding that's been filed before the patent office is going to simplify the issues that I need to resolve in this litigation that I have to decide on. And as you can see, across the panel here, or across the final row, courts are often hesitant to find a substantial likelihood that the stuff is going to be simplified for them, the issues are going to be simplified for them, until you have an institution decision. And when you look into case law on ex parte reexam, you might be thinking, well, a stay then should be more likely if I have a grant of the request. But a grant of the request is not a rejection of the claim. So there are a lot of courts that not only look for that grant that says, yes, you have a substantial new question of patentability, but an office action that says these claims are actually now rejected based on the prior art that's been presented. So in terms of timing, the longer you can wait and the more feedback you have from the patent office, whether it's the PTAB or the CRU, the more likely you can show to a judge that it's beneficial for them to stay the case, because that's really what it's all about. Are you going to make their job easier? Okay. That said, there are a lot of district courts that will generally not consider a stay regardless of how far along you are.